Thank you for joining us for this second webinar of Day 3 in CyberWeek 2016. We are about halfway through CyberWeek, and the fun is still going on and just beginning in a lot of the forums. So please do go out and check out the engaging conversations that are taking place in all the discussion forums throughout CyberWeek 2016. It is really a fantastic opportunity to connect and look at some of these important issues related to online dispute resolution. And thank you for joining us for this live session today, because we are going to be looking at a very important advancement in online dispute resolution and dispute resolution as a whole that is brought to us by our good friends over there in the European Union. And they are leaders in the field by, mandating or operationalizing the use of online dispute resolution for consumer-based conflicts, which is just fantastic. And that, happened earlier this year, but we are going to get an update from Ria Papadimitriou, who will be sharing her insights about what has been taking place in Europe since the resolution, or the conflict resolution, online dispute resolution mandate came forth. Ria, I'm going to hand the ball over to you, but thank you for joining us today.
I will start right away my presentation. I will say beforehand that this is part of the research I am conducting, which is part of the research concerning my PhD research. And the topic, as you can see, for today's webinar is the ODR platform of the European Union that has already been set out and is operational since 15 February 2016, this year. And I will stress a few topics that it was part of my research from the available data as we had them from the ODR platform this year. So I will start right away. What is this research about? It has to do about the ADR entities, which ADR entities are participating for the time being, the disputes that are submitted, that are eligible for submission, the fees and the cost that has the consumer or the trader has to bear for the submission of their disputes. We shall also see the average time for the resolution of the dispute, and also the two other things about it concern the physical presence that may be required by the ADR entities and the way the submissions are being made, the reasons for the denial by the ADR entities. And finally, I will say a few words about the binding outcome of the procedure. So, starting right away, I will start with the ADR entities. For the time being, and I will say here in this point that all the data that I have collected, processed and verified dates back to 7th May 2016. Actually, they are the first data that were available from the ODR platform, and we can see from this first information we have in hand that for the time being, 188 ADR providers are participating in the ODR platform, coming from 23 EU member states. We can see here on the right the member states that are participating with the respective number of ODR providers. For the time being, and this is also for very recently, I have checked the website of ODR of European platform ODR. 5 EU member states are without representation, and these are Spain, Croatia, Luxembourg, Poland, and Romania. As we can see further in the next slide, most of the ADR entities, in about 50% of them, are being represented in the EU platform with 1 to 5 ODR providers. And but actually, we can see that UK and Denmark are participating with more than one. Actually, for UK is 36 and Denmark 27. And of course, the 5 member states that have not so far registered any ODR provider so far. So, how about the disputes that are eligible for submission to the ODR platform of the European Union? First are the disputes concerning consumer disputes about goods and services. Also, financial services are included. Disputes concerning services in the postal field and the electronic communications. And second, we can see here the field of disputes arising in the health sector, in the transport field, and the energy and water supply. The first 6 categories of disputes that are eligible for submission are, we can say, the most frequent that can be submitted to an ODR entity. Yet there are disputes such as disputes arising out of legal or accounting services, or education services, or leisure services such as gambling, that there are respectively ODR providers that can deal with them. In the subject matter of these disputes, who can submit these disputes? As the directive says, the disputes can be submitted by the consumers to the traders. A complaint about a consumer to the trader. Nevertheless, this is not restrictive to the ADR providers. They can stipulate and they can say that we can take other complaints. For example, complaints coming from traders to consumers. Nevertheless, for the time being, this percentage is up to in about 4%. This means that most of the ADR providers deal only with complaints that are submitted from consumers to the traders, and not vice versa. And following, another very important issue of the ODR platform that the directive came to give a solution is the fees and the costs that apply to these disputes, these procedures. We can see here that in most of the cases, in 53% of the cases, there is no cost applied by the ADR providers to the complainant, or which may be the consumer or the trader. Nevertheless, there are cases of ADR providers that apply costs and a fee to the trader or to the consumer, or both of them. We can see here that the smallest percentage, in about 6% of the fees and the cost applies onto the consumer in a very few cases. That's why, that is because the directive, the directive says that the cost for the consumer that applies for the resolution to the respective ADR provider has to be for free or at a nominal fee. So at most of the cases, we can see that the ADR providers comply with this directive's requirement. Another requirement that is set out by the directive is the time for the resolution. We can see here from my research that measured in days, we can find a more fast and speedy resolution in countries such as Slovenia, Malta, Hungary, or UK, for example. But on the other hand, Netherlands, Czech Republic, or Denmark have an average time for the resolution and for the procedure more than 19 days, which is above the threshold that the directive sets out in Article 8, paragraph E of the directive, which is the 90 calendar days. In this time frame, the ADR provider has to produce its resolution, but nevertheless has the possibility to extend the 90 days period in the case that it's going to inform the parties about the expected length of the conclusion of the dispute. We can see here on the right side, on the right chart of the presentation here on the slide, that some countries, for example, Germany, Denmark, and Netherlands, as I said before, are above this 90 days threshold. And of course, they have to, in the future, to comply with this time requirement. Nevertheless, also there is Slovenia, as I said before, Malta, and other European countries that are within the limit that they have to produce the award for the consumer. So another issue that I have statistically tried to measure is the requirement of the physical presence that is is required by the ADR entities, and the way that the submissions are made. For example, for the physical presence, in most of the cases, in about 69% of the cases, the ADR entities do not require the physical presence of the parties or their representatives. Nevertheless, there are ADR entities that require physical presence. Now, in terms of how is the complaint is submitted, in most of the cases, we can say it is split. Half of the cases, the ADR entity requires the complaint to be written, accepts only written submissions, but the other half so far accepts written and oral submissions by the consumers. Here you have to bear in mind the principle of effectiveness according to Article 8A of the directive, which says that the procedure should be available in easily accessible both online and offline. So the ADR entities have to give the possibility for the consumers to be physically present or not, and also to submit their complaints both orally and written. It's very important to achieve this the effective redress of this kind of disputes. So how about the reasons for the denial? This is very crucial because ADR entities may refuse to deal with a consumer dispute, a consumer's complaint. This can be for 6 reasons that are restricted provided by the directive. And this is the following. First, if the consumer has not prior attempt to submit his complaint to the trader. This is one of the main reasons that most of the ADR entities will not accept the complaint. Another reason for denial is when the complaint by the consumer is frivolous or vexatious. And also when the consumer has already filed his case before a competent court or complained before another provider. In the cases that it is already pending, or even in the cases we have already a result. Another case for the ADR to refuse to accept a complaint by the consumer is when the providers, when it is against its interest, maybe it's its effectiveness. Also, when the ADR provider sets a time limit for the consumer to make this complaint. But here we can say that this time limit cannot be lesser than a year according to the directive, upon which the consumer has addressed his complaint to the trader. It gives this flexibility to the consumer, at least 1 year, to have the time limit and the possibility to address his complaint. And finally, when the value of the claim is beyond or above the monetary threshold that is set by the provider. From these 6 reasons for denial, we can say that the most prevalent for the time being, that most of the ADR entities accept and use in practice is the third one. And we can see from the majority of the ADR entities that they are not going to accept a complaint from a consumer when his case is pending before another provider or before a competent court. And the less frequent, I may say, is from my research, is when there is a value, the claim is above or beyond the minimum threshold that is set by the provider. Most of the ADR entities does not set this reason for denial at all. Most of them they are opting for the first 4 or 5 of them. So another issue that is very important for a consumer that is going to seek redress to this ODR platform is the binding outcome of the resolution he is going to get. Most of the cases, out of these 188 for the time being ADR entities, the binding will not be, the outcome will not be binding for both of the parties. So they can seek for redress to the competent courts or mediation, arbitration, etc. But there are cases that this resolution may be binding or imposed by the ADR entity. This percentage for the time being, according to the data available, is up to 50% in about. But there are some cases that, and this is very crucial, that the outcome may be binding. This is very small percentage, and about 8%, that the outcome may be binding also for the consumer. This is very important because in these cases, there is also the guarantees of the directive and the requirements that the ADR entities have to comply with. And this is very important and also for the enforcement issues and recognition issues of the resolution achieved for the consumer's part. When the binding is outcome, we have to bear in mind always when I say we, I mean of course the ADR entities that are going to apply and resolve the dispute. The three principles that have to be followed are the principle of fairness according to the directive, the principle of liberty, and the principle, of course, of legality. According to the first one, the consumer has the right to withdraw at any stage of the procedure, which is very important because ODR is a procedure that is voluntary. And secondly, the agreement may be, there may be a binding agreement about the resolution, but this agreement has to be stipulated, concluded after the materialization of the dispute, not before, and with prior, of course, notice of the consumer that the agreement that is going to be produced by the ADR entity or imposed by the ADR entity will be compulsory for him. In any case, we have the third principle, very important, that this imposed solution has to abide with the mandatory rules of the consumer's protection in his habitual residence. This means that there are strict provisions in every country when we have the respective national laws applied that the consumer cannot be deprived of. And especially concerning very fundamental rights of consumers. And finally, this goes without saying, of course, that there's also Article 47 of the Charter of Fundamental Rights. It has to do with the access to justice, and the ADR entity has to ensure that not by its procedure that the protection of the consumer and his willing to go to the competent court is not impeded. So when the ADR entities have all that in mind and apply that all in action, so we can say that there will be a solution that can be imposed, and it is legally binding for both the trader and, of course, the consumer. So this was the first step. I tried to collect and process in a way from what we had available from the ODR platform. I should say again that there is all this data is since 7th May 2016. That may be changed, maybe new ADR entities came into play, and if anyone wants to see for himself how this platform can work, he can visit the following link here I am presenting, which leads right away to the ODR, EU's ODR platform. That was all for me. It was a brief presentation of the first result I had so far. I hope you find it useful. And if you have any questions or anyone wants to contribute their insight or their information from their respective country with respect to the implementation of the directive and the regulation in action, you can also leave any comment or your thoughts or your insights into the discussion forum above the presentation here on the CyberWeek platform. If you have any questions, I will be happy to answer to you.
Well, thank you very much, Ria. Wonderful presentation of what's happening in Europe. And let's open this up for discussion and see what people think, what thoughts you have, what questions you have, other folks in Europe, experiences that you've had with this new directive. You can either type in the chat box if you don't have a microphone, and we'll incorporate your comments and questions into the conversation. Or if you do have a microphone available, please raise your virtual hand, and we will call on you accordingly. And I see we have a couple hands up already. Graham will go to you first, and then to Jill Hanley.
Okay, thank you, Brian, and thank you very much, Ria, for that overview. And particularly, I was interested in the stats of the actual application. I think, as you may know, I'm a big critic, not so much of this legislation, which I've welcomed, though it could be improved, but by the way it's been implemented. And I was interested in the slide that showed that in 31%, I don't know if it was cases or countries, the procedure requires a physical presence. So the procedure of the ADR entities requires the physical presence. Now, that seems to be a direct contravention of Article 8A of the directive, which says that the ADR service should be easily accessible both online and offline. I'm wondering, obviously I'd like to know, perhaps you can send me later, which countries and entities, or which countries have approved which entities that require physical presence. We do have it in a couple of cases in the UK, and I've already raised that with the authorities. But it does, of course, cut really against what the whole point of this is, to increase access to justice, to online dispute resolution. Do you have any more information about those entities?
Yes, in my research, Graham, as a matter of fact, I don't have it in handy here, but I could write it down on the discussion forum above, and I don't know if you want some more details about which countries or which entities are requiring this the physical presence. It was something that also.
If you've already got it, then both. But not don't go to any trouble to find it out. But obviously, if whatever information you have, both on entities and on countries.
Yes, of course. I can hand it to you if you like, both through the discussion forum or through the mail. I tried to have them before me, but the whole research was about 200 pages to have it printed. So I will have it to you. I will send it to you, and I will give some examples. I don't know if it's if I can do that with names of the ADR entities.
Oh yes, please name the names.
Okay, so I will put them more general without the names on the discussion forum, and I will send to you by mail in more detail.
I'll just add, I know some people are asking,
yes,
I've named the names in the UK of very big, well-known high street names: John Lewis, TK Maxx, PC World, Kerry's, big companies that are grossly breaching the regulations, the implementation, by not even having the web link on their websites to the platform, and they seem to be quite happy to ignore it.
Yeah, I would agree with you with that on that, because I think not accepting just non-physical presence is something that is against with the directive, and we should see more on that.
Thank you.
Thank you, Graham, and thank you, Ria. There's a kind of a follow-up to that, just kind of looking for further clarification about the physical presence. Now, is this something required by the ADR provider, or is this something that is requested by the parties involved in the conflict?
You see, Brian, when the ADR provider participates in through the national points and accordingly through the Commission and the ODR platform, sets his requirements, what kind of disputes he accepts, in what form, written or oral, if he requires the physical presence or not. So these all components are part of the ADR's entities' way of providing its services. For the time being, we're expecting to see how this is going to work in practice with the participation of the consumers, but for the time being, this is the rules that are set by the ADR entities.
All right, well, thank you for that and responding to the follow-up. And Jill, you had your hand raised. Did you have a question or comment?
Yes, thank you, Ria, first of all, for this interesting data. Could you comment on whether all of these providers are private? I know Graham just referred to the fact that some of them are, or are some of them government-sponsored? What's the breakout there?
Yeah. Because I had the chance through the research to see names, and we could see whether from the names, if I may say, whether they are national or private. I could say that most of them, for starters, are national points of ODR entities. But there is a large number, especially in the UK, as may Graham say more on that, that there is a great portion of private ADR entities. And as Greece is concerned, until 7th May 2016, the two ADR entities that was registered with the platform and the ministry, and in the ministry and the company ministry here in Greece, they were national. They were not, and actually it was a kind of a typical procedure for some ADR entities to be registered. It was not an initiative partly from government or partly from other organizations or trademark associations. It was not a substantial ADR participation, if I may say. But in the future, I think, as we have already seen from other countries, that also, with respect to Greece, we're going to see private institutions providing ADR and ODR services. But most of them, for the time being, I think, especially when the number of the ODR providers are between 1 to 5, which is most of the cases, they are national.
Thank you.
Yeah. If you want, I can't just mention what the position is in the UK. There are some statutory bodies, that is, like in energy and banking, where these bodies are legally required to provide ADR services before this legislation. But the rest of them are private. The majority are private. Some of them are associations, trading associations. You know, if you sell furniture, you can choose to join the association, and then you have to abide by their rules and agree to their decision. The largest, by far the largest provider is Ombudsman Services, which is a private body and is actually the giant taking sucking up most of the work. The saddest thing, and this is one of my general criticisms, because ADR has lumped two totally different processes, arbitration on the one hand and mediation, arbitration being the quicker, the cheaper one to administer, has largely taken over. There are 3 bodies who are entities approved who provide mediation, but they're struggling to get work.
Thank you.
Thank you, Graham. That was very useful. I think the case is in about the same here. The two, for the time being, ADR entities are statutory entities that come from the government. And actually, as far as I know, they participated in the draft of the legislation that implemented the ADR and the ADR Directive, mostly. But I'm hopeful that we're going to see more private initiatives and coming outside the business world, because as you said, business associations, there's another issue. I actually touched upon that last year about the funding that these institutions may have according to the directive, because there is also the partiality issues here. You cannot solve impartial dispute resolutions for your business, for your traders associations, where you are representing these traders. So there's a thing here. I would prefer to see in the future more private initiatives without the funding and the participation of trade associations.
Thank you, Ria. And I've got a question. Not sure if you covered this up front, but somebody was wondering, are there any stats on the number of cases that have been filed and ultimately resolved?
No. Unfortunately, there are no such statistics at the time being. As I said before, this research I have conducted and produced these statistics that I have presented to you are the sole statistics for the time being in general. As you can see for yourself, and that's why I gave you the link for the ODR platform, the statistics we're expecting from the European Commission, we have none yet. But I am hopeful that we are going to see the first statistics in the spring of 2017, because according to the directive, the ADR entities have the obligation to provide such data annually and a report, if I may say, with all the disputes that have been submitted, the actual length of the procedure that have been taken to resolve. And because of this obligation, I expect that most of the ADR practitioners to see the first data available officially from the European Union this spring, hopefully. I hope I covered your question.
Yes, thank you. I believe you did. And Bill, I saw you had your hand raised and your microphone unmuted. Did you have a comment, question?
Well, I was going to ask the same thing. What kind of data is expected to be available for viewing as a kind of consumer dashboard, or it sounds like we've heard that there isn't a lot of it yet, but that maybe we'll have more in the future. So I took my hand down.
Thank you, Bill.
All right. First of all, I'm busily, while listening to the conversation, trying to find an email I had not so long ago where some preliminary figures were issued from Brussels, I think informally, and also in a conversation I had with the head of Ombudsman Services, which, if you remember, I said is the largest. They are very heavily storing and analyzing their data. And Bill, I think if I can get hold of, I think it's going to well, I'm not quite sure, but I was asking how available, what sort of studies there will be. But the Ombudsman Services one will I think they've gone to great effort to number crunch, to actually break up these cases into their component parts so that there can be some useful analytics derived, because I think that would be one. And again, I think this whole legislation will turn out to be very beneficial, but I think just in its teething phase, it's not working. There's too many people ignoring it, particularly traders, because one of the main weaknesses, it's not mandatory. Traders have to notify everybody of an ADR system available online. So I always say, great, what we've been waiting for in ODR for years. The businesses have to promote ODR, saves us having to do it. Hard enough job as it is, but it ain't working at the moment. I did have one question, Ria, on this question of how they notify. So they have to notify people in dispute they don't resolve of one of the providers, and they have to also link to, when they're selling online, they have to link to the EU platform that will send cases back to their local ADR providers. And perhaps if we have time, we can consider the awful problem, what if Brexit actually happens? What does that mean to the UK and that platform? But under the rules in the directive, it says that the companies must provide an easily accessible hyperlink on their websites. Many don't, most don't have it, but some that claim they satisfy the rule by burying it deep in the terms and conditions. Now, as we all know, the lie that all of us make almost on a daily basis is I have read, understood and agreed to these terms and conditions. So nobody reads the terms and conditions. So if anything is buried like a line in the terms and conditions, nobody will see it. It's again, do you have a view, or have you discussed with anybody about the interpretation of that requirement? That I would say easily accessible means a hyperlink. I was hoping a little icon with the EU circle and stars on the homepage.
Graham, I'm very glad you are mentioning that, because I have already thought about it and discussed with some colleagues of mine. There is actually a thing here about the notification that the traders have to give to the consumers. And as far as Greece is concerned, and something that it's something that it was a matter of personally I had to think through. It is a notification. According to the directive in Article 13 and the regulation, because I think it's Article 14, the traders have to provide a link in their website with the ODR platform at first, for starters. Okay. And if they are committed or have chosen a specific ADR entity, they are also obliged to give also the respective link. And we can see from I think it's the regulation that, let me see that. I think, no, it's not the regulation. I think it's Article 21 of the directive. There are also penalties for this such of an omission. And no one, at least in here, I don't know how the situation in the other European countries or in the UK, but here in Greece, when I talk with traders, and especially with the traders who they have e-shops and conduct e-commerce, they have no idea, and even big e-commerce e-shops, they have no idea that they have to abide with that regulation, or even they have this kind of obligation. And still, the penalties in the national, as far as Greece, as I say again, is concerned, the penalties are not implemented yet with specific rule of law. So how are we going to promote the ODR platform, the ODR resolution, without the players not being informed and not complying with the directive and the law? So this is I'm glad you are mentioning it. You have mentioned it, because it's an important issue. I think we have to raise itself, mediators, lawyers, awareness to the public, and especially the traders and the respective trade associations about this obligation.
I was interested in the the length of time that there is from filing to resolution, was the numbers that you showed us, is that from the first year of activity, how long it took, or is it how long they say in their policy?
If I understood your question correctly, the length of the time, the average length of the procedure is from the time the complaint is filed, the complete file of the complaint to the ADR entity until the conclusion and the final award. This is set out by the directive to be 90 days. So if I am an ADR entity and you are a consumer, for example, and give me your complaint in full details and hand it over to me, I am obliged, according to law, to produce a resolution in the time frame set out by the directive, which is the 90 days. Or, according, I think it's Article 8 of the directive, I may extend this time, this period, but I have to give notice to you as a consumer that, you know, okay, I will not deliver your dispute, the resolution about your dispute in 90 days, but it will take that each time to have your resolution, because it all comes down to the effective dispute resolution. Effective means cost effective and time effective. If I'm going as an ODR entity to produce a resolution after a 5 months, especially when we talk about ODR resolution, not even arbitration or not mediation, we talk about fast track resolution. So the time frame set out is 90 days in general.
And the data that you showed us is what they're doing currently. So was it Slovakia was fast, 30 days, and then UK was slow? Is that from actual timing of cases that were submitted in the last year? Are they reporting on their success of how fast they're actually achieving outcomes, or is that what they plan on offering?
No, actually, this. Thank you for the question. It's very critical. The time frame has to do with the data that each ADR entity provided with the platform. For example, I am X, not to say names. Okay, the X ADR entity, and I say that according to my service that I provide and my rules, you should expect your resolution in that time of days. But the first data, actual data about this time frame, are not. We have no data on that for the time being. Hopefully, the spring with the actual that are going to come up from the actual operation of the ODR platform.
We're still waiting. Thank you.
And I always felt when they said it would be 90 days, that this seems an extraordinarily long period of time.
Yeah.
For ODR. Whereas I thought this legislation would help promote online dispute resolution, it is in danger of giving it all a bad name. Firstly, because of the length of time. Because this equates to the period of time that ombudsman services traditionally have taken, or up to that, in more complicated, say, banking disputes or whatever. And I think a lot of the consultation was with the existing ombudsman industry operating arbitration resolutions, rather than with the ODR community as such. So that length is an outside period, but it seems awfully long. And even despite that, we're looking at these wonderful slides you produced, Ria. It's really helpful with these stats of even Netherlands being twice as long. The other thing is, as I mentioned before also, the fact that most of it is arbitration, and as you rightly said, Ria, there are issues about the trust in the neutrality of the ADR entry, particularly when they are effectively paid by a trade association made up of contributions from members of that association, and then having to resolve a case involving one of those members, they will be concerned that if they resolve too many in favor of the consumer, then they may lose the gig when it comes up for retendering. And so these all cut to the core. I think there is provision to rethink and amend in the future. And I think it will help for there to be some reasoned lobbying at the Commission and to our respective state agencies to help get some improvements and tightening up of this. But I think it still can serve an extreme useful purpose, because consumer disputes are where most people will come across far more frequently than more complicated disputes. And if they get to, I mean, it's great that it actually has ODR, those letters in the title. I think I may stand to be corrected. I think it's the first law that's ever been passed that about ODR itself. But it isn't real ODR. It doesn't cover it, and it has all these weaknesses. So we need to change all this and try to help get this improved. Otherwise, because it's the most frequent type of dispute for people, the public will gain a negative view of what this ODR is all about.
Graham, you have to rejoin the EU to get your voice heard.
Hey, we haven't left yet, Bill. You heard it first. We're not going to leave, don't worry. I see Theresa May's game plan.
Breaking news from Graham Ross. Yes. Well, thank you very much. Thank you very much, everybody. We do have a request here, Ria, and I'm hoping maybe you can put it up, or somebody that has a quick access link to it in the forum that this session lives in CyberWeek, but somebody was hoping to get the actual language or policies that this directive set forth. That'd be fantastic to share so people can review that as well.
Yeah, I'll post, or maybe Ria will. It's up there.
Perfect. Thank you, Graham.
Yeah.
All right. We have a few minutes left for this session. Are there any final questions or comments that people have out there? Or Ria, any final thoughts that you would like to share with us before we close out the session for the day?
Actually, and one last thing, I would like to add to what Graham said before about the 90 days, and of course the extension that the ADR Directive provides. I think also for this time, for this sort of disputes, and to make people go this direction, especially the consumers and the small claim disputes go this way. I think the 90 calendar days are a bit quite some time for the resolution of the dispute. I think it would be better to have to see again this time period. Maybe in a later stage of the directive. I don't know, from the competent authorities or from the national point. National points in the ADR entities to try to deliver as soon as possible, as we saw with I have it on screen, as Slovenia, Hungary, or UK is in 56 days, to try to deliver as soon as possible in order to gain the trust of the consumers and the traders, of course, the users of the ODR platform. This will be my first remark. The other one would be to for everyone that is interested, especially within Europe and from EU member states, if someone is interested to give his insight from his national point of view regarding the ODR platform, the respective legislation in his own country, it will be more than welcomed. That's all for me, Brian.
Thank you, Ria. Yes, and as I said earlier, this session does reside on a discussion forum, so anybody that has thoughts or perspectives from your place or location in the European Union, please do share them in that forum. It would be a really great contribution to the conversation. And with that, we do have one more question. I think we do have time for one more question. We have a question from Marissa that states first that she is concerned that the non-binding outcome rate is very high. Do you have insights into why this might be?
The non-binding outcome, I suppose because of the three principles I have already mentioned and the Article 47 of the Charter of Fundamental Rights, and we can also recall to our memories the compulsory mediation that was made by the Italian government in some cases, especially consumer cases that were handled through ODR for online resolution, the famous Alassini case, and I think most of the ADR providers are very, if I may say, they try to be very close to the legality of the directive, and not imposing binding, because as we can see, as we know, if we can say the rule is the non-binding, the basic norm, which is more safe, if I may say.
Yeah, and I could just add, certainly from the UK perspective, possibly the majority of cases come from the statutory scheme. So that is those services and products that by law have to be decided out of court by an independent ombudsman, so banking, power, energy, telephones, and what have you. And in all those cases, they are non-binding. And beyond that, we've got Article 6 of the European Convention on Human Rights, which prevents, certainly in Europe, pre-transaction binding commitment. So nobody selling to a consumer can require, if there is a dispute, that an out-of-court service has the power to make a binding decision. Obviously, a lot of the ODR culture from Amazon onwards works de facto the other way. But Article 6 says, of course, everybody has the right to an independent tribunal, generally interpreted as a state tribunal, i.e. a court system, not a traditional tribunal. But of course, they can bind themselves, consumers, after the event. So once the dispute has erased itself, they can be offered voluntarily to say, will you participate in this ADR? By the way, you agree in advance that the decision will be binding. This, of course, only applies to arbitration. Mediation services are non-binding up to the point of a resolution, and then usually one would make the resolution binding to avoid wasting time. On that point about Article 6 and Convention, a lot of people think that you can't, that ODR itself is a threat to Article 6, because especially as courts increasingly are looking to build it into the court system. Certainly in the UK that is happening. But the Council of Europe has made a declaration last year following an investigation by the Human Rights and Legal Affairs Committee. The Council of Europe is the body responsible for the European Convention on Human Rights. It created it and monitors it. And it decided that ODR is not a threat to Article 6. It enhances access. However, the systems must not have certain, well, there's certain provisos, that the systems must not give an advantage to the person who uses them day in, day out, as against the first-time user. But so Council of Europe thinks ODR is a good thing. This regulation on paper appears to do that. On grass, as they say, on the football pitch is not as good as it is as the manager planned it in his tactics.
Yes. Well, good. It seems like there's room for exploration, assessment, and improvement, and still puts us a little bit ahead of where we are here in the States, but maybe that's a good thing. We can see how it all shakes out and see if implementation can be improved upon. Thank you, everybody, for this wonderful, engaging session. And we're going to close out this session for today. I do invite you to head into the forums and see the conversations that are taking place there. And we will be back with another live webinar tomorrow. We're going to be looking at online peer mediation and some wonderful programs out there to help people deal with issues such as bullying with online dispute resolution. So thank you, everybody, and have a wonderful rest of your day. Take care.
Thank you. Bye-bye.